Hotels housing asylum seekers set on fire. Mosques and immigration centres targeted nationwide. Violence, racist attacks, looting. Police overwhelmed, injured. Communities terrified. A wave of unrest started after an attack at a Taylor Swift dance class in Southport, but fueled by racist misinformation.
Between the 30th of July and the 7th of August 2024, an estimated 29 anti-immigration demonstrations and riots occurred across 27 towns and cities in the UK. On the 30th of August 2024, the NPCC reported that 1,280 individuals had been arrested in connection with these events, with 796 facing charges. By the 2nd of September 2024, the government confirmed that over 570 individuals had been brought before the courts for offences such as violent disorder, assaults on emergency workers, arson, and for encouraging violent attacks online. Violent disorder carries up to 5 years imprisonment, and riot can result in up to 10 years in prison. What defines a crime? How should society respond to criminal behavior? These questions may appear straightforward, guided exclusively by the law. However, the reality is far more complex. Beyond the written statutes, policy plays a critical role in shaping how laws are enforced and justice is administered. Is the criminal justice system truly insulated from political influence? Is it purely governed by the rule of law, or is it influenced by political interference, especially in crisis? Can government policies, often driven by public opinion, emergencies, or political priorities, dictate how police operate, how prosecutors file charges, and even how judges determine sentences? In other words, as one of our valued community members put it, are our laws such that they can be interpreted and used at will, like an undercover dictatorship? Or did I miss something? Welcome to Spoken Injustice, where we put the criminal justice system in the dock. In this video, we explore how policy, alongside law, influences our criminal justice system, highlighting critical questions about fairness, transparency, and the intricate balance between justice and politics. We'll begin by revisiting the basics, examining the concepts of law and policy and their respective making processes. Next, we will discuss advantages and drawbacks of the interaction between law and policy, providing real examples of current and past policies before concluding with the potential reforms that could improve the system. Before embarking on this intricate journey, I encourage you to like and share our content and subscribe to our channel. Your support enables us to continue breaking down complex issues such as this into digestible pieces, providing you with the insights you need to form your own conclusion about our criminal justice system. Don't forget to join the discussion in the comments below. Now, get ready, get set, let's go. The handling of the summer's 2024 riots, as highlighted at the start of today's video, serves as a prime example of how law and policy interplay in practice. From the outset, let me clarify that we will not conclude whether the actions taken at the time were right or wrong. Our aim here is to illustrate how policy operates in practice and assess whether reforms are needed to address transparency and accountability in our criminal justice system. In the case of the mentioned riots, there is no doubt that policy facilitated facilitated the rapid processing of defendants despite court backlogs, with judges imposing harsh custodial sentences aimed at deterrence despite concerns about prisons overcrowding, demonstrating how policy directives can swiftly reshape criminal justice practices practically overnight. But what exactly is policy? Who shapes it? And how does it interact with the law? Let's begin with the basics, as we always do, by revisiting the concepts of law and policy and their respective making processes. In simple terms, law is a system of rules recognized by a country to regulate its citizens' actions, enforceable through penalties. As per the lawmaking process, known as legislation, this is a function of the legislative authority which rests with Parliament. A proposed law is first outlined in a green paper if consultation is needed, or in a white paper if action has been decided. It is then introduced in Parliament as a bill. It is then debated in multiple sittings in both houses of Parliament, the House of Commons and the House of Lords, and often amended several times before approval is granted by both houses. To become final, a law requires royal assent, which, though technically subject to veto, is nowadays a mere formality. Policy, on the other hand, refers to a set of ideas or plans for addressing specific situations officially adopted by a government. It refers to a course of action planned by the government on a particular subject. Policy making falls under the executive branch of government, which has broad discretion to formulate policies in many areas of public importance, including criminal justice. The policy making process is far from straightforward. Although many have attempted to represent it through various visual diagrams like this, the reality is that it is a dynamic and fluid process. Generally, it involves several stages: agenda setting, formulation, evidence gathering, debate, evaluation, and implementation. However, policy making is often marked by duplication, reversal, and unexpected shifts in approach, making it highly unpredictable. While laws are fixed and can only be altered through legislative action, policies are more adaptable, evolving to ensure that decision making and practices align with society's ever-changing goals. You will be excused to assume that laws are more dependable than policies due to their stricter formulation process. However, this in reality is a myth. In fact, false narratives can infiltrate the lawmaking process as well. For instance, consider the law that replaced jury unanimity with majority verdicts. This change was promoted under misleading claims, suggesting that criminals were boycotting trials and tampering with the juries. We explored these issues in great detail in our video Majority Verdicts Passed in Haste, Time to Reconsider, linked in the description below. In reality, there was no evidence at all to support these claims. In fact, the evidence at the time suggested a different picture, which was totally overlooked. Roy Jenkins, the Home Secretary at the time, offered a detailed analysis centered on the Central Criminal Court, which at the time handled 5% of all trials on indictment. He noted that there were 49 cases of jury disagreements that year in that court. Jenkins argued that these figures supported the introduction of majority verdicts to save the significant time and efforts required for retrials. However, Jenkins overlooked a critical point. Of the 49 cases, which then resulted in retrials, 25 resulted in conviction after a retrial, and 14 led to acquittal, while 9 ended in a second disagreement with no further action. One case was not retried. This meant that a substantial number, i.e. 23 cases out of the 49, led to either acquittals or no further action upon retrial. Under the majority verdict system, these individuals would have been convicted instead. A striking example is the case of Andrew Markinson, who was convicted by a 10-2 majority. Had unanimity been required, he might not have been convicted at all. His case would have gone to retrial and possibly resulted in an acquittal or a further disagreement and therefore no further action. This highlights the profound risks and injustices that arise when laws are enacted based on false narratives rather than a genuine reliance on data analyzed as evidence for or against their implementation. In other cases, the law may define only certain aspects, leaving many details to be determined through regulations. These are rules that the government can enact without undergoing democratic parliamentary debate. For instance, an act may provide a definition, but then allow the government under certain circumstances to refine or expand it via regulations. A recent example of this is the Police Crime Sentencing and Courts Act 2022, which amended the Public Order Act 1986. This amendment granted the government powers to expand the definition of serious disruption in the context of public protests. Effectively, protesters could be held liable based on what the government unilaterally defines as serious disruption. In May 2024, the High Court ruled that a statutory instrument issued under this authority was unlawful. The court determined that while the government has the legal power to clarify the term serious disruption through statutory instruments, the instrument in question effectively altered its meaning. This change lowered the threshold for police intervention, redefining serious disruption a more than minor disturbance, a clear deviation from the intended definition. The court emphasized that as a matter of ordinary and natural language, more than minor, it is not within the scope of the word serious, and consequently ordered the statutory instrument to be quashed. The Home Office appealed the decision. The appeal was heard on the 4th and 5th of December 2024, and as far as I am aware, no decision has yet been handed down. In short, the takeaway point here is that we should not assume law is inherently more reliable than policy. Let's now explore the connection between law and policy. Law and policy are closely interconnected, and their relationship plays a vital role in various areas, including criminal justice. In short, whilst the law provides the foundation for defining crimes, protecting citizen rights, and guiding the justice system's functioning, policy helps to implement laws in a way that aligns with broader societal goals. The purpose of policies is to inform decision making, improve practices, and ensure consistency across the criminal justice system in many areas of criminal justice. For example, policing policies such as stop and search protocols, rehabilitation programs aimed at reducing recidivism, or sentencing guidelines issued by the Sentencing Council. So, how do policy and law interact? Policies often shape or influence the creation of laws. For example, a government policy to reduce knife crime may lead, following implementation and evaluation, to new legislation with stricter penalties, as it happens, for example, with the Offensive Weapons Act 2019, which received royal assent in May 2019. Conversely, existing laws may drive the development of policies to ensure their effective application. For example, enhanced police training on upholding human rights to ensure effective application of the Human Rights Act. The flexibility of policies offers distinct advantages compared to the rigidity of laws. While laws are fixed rules that require formal processes, such as legislative approval, to be amended or repealed, policies can adapt more readily to changing circumstances and evolving needs. This fluidity allows policymakers to respond quickly to emergency issues, test innovative solutions, and refine strategies based on feedback and new evidence. Additionally, the adaptable nature of policies fosters experimentation and iteration, enabling governments to pilot programs or approaches before embedding them into legislation. This flexibility ensures the policy measures remain relevant and effective in a constantly changing environment. As you know, we have often expressed our mission to humanize wrongful convictions, and even though we have placed a focus on wrongful convictions, we actually foster a truly humanized approach which must encompass the entire criminal justice system, which demands fairness, transparency, dignity, and respect for all individuals involved, not only victims and broader communities, but also defendants, even at the point when they are identified as offenders. If we want to humanize the criminal justice system, policy can indeed serve as a powerful tool to bring about meaningful change. For example, policies can be designed to promote rehabilitation over punishment. Shifting focus from punitive measures to rehabilitation and reintegration into society can reduce recidivism and improve outcomes for offenders. Policy can come into play to address systemic inequities, actively combating racial, gender, and economic disparities in the system by, for example, improving access to legal representation or diversifying decision-making bodies. Policy can be deployed to support victims and communities, prioritizing restorative justice, which seek to repair harm and rebuild trust between offenders and affected parties. Policy can also ensure procedural fairness, for example, by simplifying processes and providing clear information. Policy is a powerful mechanism for addressing societal needs and adapting the criminal justice system to evolving demands. This seems great, right? Flexibility and adaptability is actually what our criminal justice system needs. However, the success and effectiveness of policies depends entirely on whether they are grounded in evidence-based practices. This ensures that decisions are informed by reliable data, research, and real-world outcomes rather than anecdotal evidence or political expediency. What are evidence-based policies? In general terms, these are policies based on proven methods which allow for measurable impact and transparent evaluation. Seems easy, right? In reality, there are many challenges. So what obstacles stand in the way of implementing truly evidence-based policies? Well, to start with, modern policy making often prioritizes speed and efficiency, especially in crisis or high-pressure environments. Also, the accelerated mechanization and the elimination of the human element in policy making could lead to decisions that appear evidence-based, but in reality are shaped by selective use of data. The increasing use of algorithms, data analytics, and automated systems in decision-making, whilst can streamline processes, risks oversimplifying complex social issues. For example, risk assessment tools in criminal justice might over-rely on historical data, perpetuating biases rather than addressing them. Mechanization can also exclude qualitative factors that are harder to quantify but vital for fair and effective policies. Removing the human element from policy making can strip away empathy, context, and ethical judgment that are critical in areas such as criminal justice. For example, risk assessment tools are often used to predict the likelihood of an offender reoffending. These tools rely on quantifiable data such as past criminal records, age, employment status. While this matrix can provide a standardized assessment, they often fail to account for qualitative factors such as personal growth, community support, or unique circumstances of an individual's life that might reduce the actual risk of reoffending. For example, a person who has shown genuine remorse, engaged in rehabilitative programs, or demonstrated strong family support might still be categorized as a high risk because these qualitative factors are harder to quantify. Other factors include relying on incomplete data or preliminary data, not to mention the interpretation of data that, even if complete, can be skewed by political or ideological pressures, leading to decisions shaped by biases. On the other hand, over-reliance on data and inflexibility could also lead to policies that lack room for discretion, which may overall fail to account for the complexities of individual cases, leading to unjust outcomes. Let's look, for example, at a policy that set out the principles of the investigation of rape and serious sexual assault in 2002. This was set out in a Metropolitan Police Special Notice number 1102. It stated that 3 overriding principles guide the investigation of rape and serious sexual assault. Principle 1, it says it is the policy of the Metropolitan Police to accept any allegation made by any victim in the first instance as being truthful. An allegation will only be considered as falling short of a substantiated allegation after a full and thorough investigation. This approach was largely misunderstood. This approach was taken in 2002 in an attempt to restore some faith lost back in those days when sexual offences complaints did not see the light of day. This was then taken to an extreme and led to the body that inspected the police in its report of November 2014 titled Crime Recording Making the Victim Count, which states at paragraph 131, crimes can and should be recorded at the first point of contact with the police in all but the most exceptional circumstances. The presumption that the victim should always be believed should be institutionalized. The practice of some forces of investigating first and recording later should be abandoned immediately. The presumption that the victim should always be believed informed the crime recording rules for frontline officers and staff, despite that same report indicating that only 6% of police failure to record a crime was due to the police not believing the victim. On the 18th of December 2014, The Guardian reported on a Metropolitan Police investigation into serious allegations that a ring of prominent politicians and members of the establishment abused and terrorized children as young as 7 more than 30 years prior and went on to kill 3 young boys. The allegations had been made by a then middle-aged man named as Nick, who claimed he had been abused from 1975 to 1984 between the ages of 7 and 16. It was reported by The Guardian, so far one victim known by the pseudonym Nick has come forward to tell of a decade of abuse he suffered at the hands of people including senior politicians and members of Britain's establishment, and of 3 homicides. Police as yet have no bodies, full names of those abused or killed, or exact location where killings took place. But the detective in charge of the investigation pointedly described Nick's allegations as true. Of course, you all know who I'm talking about. That middle-aged man was in fact Carl Beach, who 5 years later was convicted of 12 counts of perverting the course of justice and 1 count of fraud and sentenced to 18 years imprisonment. This case exemplifies the dangers of rigid policies that fail to account for the complexity of individual circumstances, resulting in profound harm to those wrongfully convicted, some of whom, in this case, tragically died before being vindicated. Despite a review conducted by Sir Richard Enriquez and a report finalized in 2016 and published in 2019, cautioning against over-reliance on complainants' accounts and highlighting the importance of balanced, evidence-based investigations, the current crime recording rules for frontline officers and staff 2024-2025 include the following steps outlined at page 7. The victim is to be believed. On the balance of probability, a crime in law has been committed. There is no credible evidence indicating the crime has not been committed. We have looked into these issues in more detail in our video, A Closer Look at the Drawbacks of Believing the Victim, linked in the description below. It is now time to draw our conclusion. While the criminal justice system operates within the framework of the rule of law, it is evident that political influence often permeates its functioning, particularly in times of crisis. From the examples discussed, we concluded that while deterrence is certainly a legitimate objective, prioritizing it during crisis, as seen during last summer riots, can result in disproportionate sentences that erode long-term public confidence in the justice system. Similarly, while it is crucial to take allegations of sexual assault, rape, or any other crime for that matter seriously, these must not compromise a fair, objective, and impartial investigation process or undermine fundamental safeguards against miscarriages of justice, such as the presumption of innocence. The public deserves transparency in how justice is administered, especially in time of crisis. The lack of clarity in circulars and guidelines undermines trust in the system. Such directives may divert resources to specific areas at the expense of others, or promote harsher sentencing, or fast-track certain trials, prioritize public safety over individual rights, and may lead to significant long-term consequences. While laws are publicly accessible, the policies that shape their application often remain confidential or difficult to obtain. The challenge lies in maintaining the flexibility that policies provide over the rigidity of laws, while ensuring they are grounded in evidence-based practices. This balance is achievable if the process of policy development is approached with caution and care, ensuring that policies are carefully crafted to serve the intended purpose effectively. These can be achieved through several practical measures centered on accessibility, transparency, and accountability, not as mere rhetoric, but as actionable principles. Let's start with accessibility. First and foremost, clear communication is fundamental to build trust and encourage engagement. Policies and their supporting evidence should be clearly labeled and hosted in an easy accessible platform, presented in a manner that is straightforward for the general public to understand. For instance, while policies are currently available on the Gov.uk website, the search functionality is overly broad. Searching by topics such as crime, justice, and law yields 157,000 results. Even with filters for relevance, date, and type, users are left sifting through a long list of unrelated documents, which can feel overwhelming. Furthermore, the presence of outdated documents adds to the confusion. Accessibility of data and methods is also essential. Policymakers should disclose the evidence sources, analysis methodologies, and reasoning behind their decisions, enabling stakeholders, including the public, to understand and evaluate the basis of policies. These are often omitted, or even when referenced, the sources and methods of analysis are not revealed. Additionally, ethical oversight is crucial. Safeguards must ensure that automated tools and streamlined processes adhere to ethical standards and reflect societal values. These must be accompanied by open stakeholder engagement, involving community members, practitioners, academics, and other experts in discussions, ensures that different perspectives are considered and reduces the risk of overlooking key issues. Regular and continuous evaluation must be ensured. Policies should include mechanisms for ongoing assessment to determine whether they achieve their intended goals. Metrics such as, for example, recidivism rates, fairness in sentences, and community satisfaction can provide insights into effectiveness. Policies should also include mechanisms for adjustment as new evidence emerges. Feedback is an essential tool to measure effectiveness of a policy. Mechanisms for individuals and communities to provide feedback or report grievances can help identify and correct flaws in policies. And of course, we must not neglect accountability and independent oversight. Establishing independent bodies to monitor policy implementation can safeguard against misuse or unintended consequences. In conclusion, accessibility, transparency, and accountability ensure that policies remain aligned with their objectives and adaptable to changing circumstances. By emphasizing transparency, accountability, and a focus on human dignity, policies can indeed transform the criminal justice system into one that genuinely serves people, not rules. A fully informed public can better advocate for a justice system that balances the rule of law with independence from political agendas. We hope the points raised here inspire a meaningful discussion on these crucial issues, which are essential for shaping a fairer criminal justice system. Let's continue the conversation in the comments below. I look forward to engaging with you. That wraps up today's session. Don't forget to like, share, and subscribe to support our mission of humanizing the criminal justice system. And remember, knowledge is power. It equips us to make informed decisions, address challenges, and drive progress. With knowledge, we can turn potential into action and create positive change. Join us again as we sit and rise in this unique trial.